Hello and welcome to Liberty Bytes. This is part of the Think Liberty podcast network. Please make sure to give us a subscribe and a review on iTunes. You can find the other podcasts in the network by going to think-liberty.com. My name is James Smith and I'll be hosting the podcast today. You can find me at James Smith Film on Twitter. I am also a contributor to Think Liberty and you can find my articles on the website. Today we're going to be talking about libertarian theory as it applies to intellectual property. And if you've been around the libertarian movement for a while, this might not be so controversial. But if you are relatively new, this is where your libertarian mettle is tested, so to speak. Because the conclusions I'm going to be drawing here are actually quite radical. They're also going to seem very counterintuitive. But I'm sure you'll see as we step through this that the logic is inescapable. And you could say that it sheds some light on what property actually is in the broader sense. I think it will be first useful to define exactly what intellectual property is. IP is the legal claim of sole ownership and exclusive ownership of an idea. And these usually come in the form of patents, copyrights, and trade secrets and trademarks. There are many libertarian controversies surrounding IP because early libertarians didn't see that there was anything inherently unlibertarian about claiming ownership over ideas. One notable example is Ayn Rand, who was very passionate about the ownership of ideas. However, some of the more radical libertarian thinkers, such as Murray Rothbard, began to question the validity of it. However, he did not go as far as, for my money, one of the best libertarian thinkers today, patent lawyer Stefan Kinsella. Stefan Kinsella is who I'm going to be drawing on mostly today because he happens to be the pioneer in this kind of thinking, the libertarian application of IP. He wrote a monograph called Against Intellectual Property, which is probably the Bible on this topic. In this monograph, he argues that none of these things, patents, copyrights, trademarks, or anything else, are actually justifiable. And of course, new libertarians at this point are going, What are you talking about? Of course we have the right to own property, don't we? We own the produce of our labour, right? And an idea is just that again. If I write a poem or a recipe or a design for a drug that's going to save millions of people's lives, then surely I have the right to sell it and make a profit out of it. But we're going to get really granular into how these things actually work. And I'm sure you're going to find by the end of this that these arguments are difficult to contend with. You'll find that after we've walked through it that it's not quite as simple as I made it and therefore I have sole ownership of it. The standard libertarian idea of property goes, we transform the land or resources with our labour, or we come to have it through trade, that somebody gives us it in exchange for something else or with a gift. And property is our best means of allocating scarce resources. And if we can get everyone to agree, or at least a good majority of people, to respect each other's property rights, then society will live in peace and prosperity, relatively speaking. But the only reason that society has this discussion at all is because resources are scarce. Nobody would ever talk about property rights if everybody could have all of the resources in the world equally without risk of being in conflict with somebody else. Two people could occupy the exact same space and use the same things, consume the same things. Unfortunately, that is not the case, and conflict is always a risk. The property rights system is a system we've happened upon as probably the best means of reducing conflicts. From this, the libertarians deduce that stealing somebody else's property or hurting their person is criminal and therefore wrong. So now let's see how that applies to copyrights. Let's say an author writes a poem. Surely they have the sole ownership over the piece of paper, at least, on which they wrote the poem on. That poem would not have existed without that person, and it was their labour that went into it, so surely they own that poem. However, what if somebody was looking over their shoulder and copied the poem word for word? Does that second person then have the right to sell that poem to other people? Kinsella and other anti-IP libertarians would say, yes, there's nothing wrong with that. But why is that? Most people would say that's a form of stealing. However, it's a categorically different thing to stealing. If somebody steals your television, then you're deprived of that television, and therefore at a loss. However, if somebody just copies your poem, you're not deprived of your poem, it still maintains the initial integrity. What's happened now is that both of you now have the same poem, so we've actually had an increase, whereas with a theft, it's just a zero-sum game. This reveals that intellectual property is not simply about having the right to which you've produced, but it's the right to make a profit from what you've produced. Property is not about having the right to make a profit from something. You have the right to seek a profit from something. Think back to the Declaration of Independence, which says that you have the right to the pursuit of happiness. You don't necessarily have the right to happiness because nature doesn't provide happiness for it. You can do your best to find it of your own accord, but if you had a right to happiness, that would represent an obligation on other people. In a sense, all rights are obligations, but there are two kinds. You can have the negative kind of rights, which are you have an obligation not to do something, you have an obligation not to steal from somebody or to hurt them, because that other person has rights. But with positive rights, you have the obligation to do something. If everyone has the right to a house, therefore society, or at least somebody, has to build a house for everybody in the world. Intellectual property is a form of this second form of right, the positive right. What it says is somebody else has to protect your profits. What that means in the real world is aggressing against other people and preventing them from seeking a profit with an idea that you have produced. So with the copyrighted poem, all that would mean is the government would have to come in and prevent the second person from using their resources as they see fit. And on the face of it, that does not sound very libertarian, does it? Pro-IP libertarians would respond by saying, if it was a tangible good such as a bike, then we still hold the same standards. If somebody stole a bike, then we would motivate the state, if we were in at least a miniature society, to go and get the bike back. So in essence, enforcing the property right of somebody else. But that's a wrong analogy. If somebody steals the bike, as we established before, then that person is deprived of it. However, imagine if somebody had invented a machine that could copy that person's bike exactly as it is, maybe some kind of 3D printer with a scanning device on it. Would that be the same as stealing? I would say no. Come back to our idea about what property is. It's a norm that we've established to avoid conflict, and in such a situation, there is no conflict. If somebody is out in public and then happens to walk past a scanner, and then person B produces a bike out of that, both of those people could go on their merry way with their bikes. Conflict would occur, though, if they recruited somebody else to go after the second person to go get their bike back and destroy it, or just prevent them from using it. So I'm just pointing out here that if intellectual property really is a real property right, then it is the only property right that causes conflict in this way. So if you're going to support it, just be aware that this is the inevitable consequence of it. In our current legal system, once you've applied for a copyright claim, you have the sole ownership of the right to reproduce and make a profit out of your poem, or whatever it might be, for a certain number of years. It depends on the country. But when does justice have a time limit? If you are the sole owner of an idea, then surely that remains as long as you're alive, isn't it? If we had somehow managed to create some technology that increases our lifespan infinitely, why then would there be a time limit on your copyright? Why do we have this arbitrary system where you can extend the length of your copyright? This is often enforced all willy-nilly. The trademark for Mickey Mouse keeps getting extended, even though it should have expired decades ago, and the original creator, Walt Disney, died decades ago. So what this really amounts to is the state renewing a monopoly over the recreation of certain goods that are based on the ideas by somebody dead. It's also worth pointing out at this point that the original IP protection laws called it intellectual monopoly protection, not property. And this partially explains why Disney is so intent on buying up new intellectual properties, recently having acquired Disney and Lucasfilm, the most profitable IP. This legalistic version of IP benefits the largest corporations and punishes the small ones. People think that IP is there to protect the little guy so that nobody else steals their ideas and incentivizes creativity. However, there's plenty of evidence to the contrary for that. It is the big companies that can afford to regulate these small people out of business, essentially. There are very few cases where the smaller person manages to win against the giant conglomerate. Being more relaxed on IP enforcement would actually increase the creativity in Hollywood, I reckon, because at the moment, a small number of companies have the sole right to make movies based on certain characters, let's say Marvel superheroes. Now, what we could be seeing is multiple producers competing on the same playing field to make the best Spider-Man movie, for example. And what the Star Wars prequels show us is that the original creator is not necessarily the best person for the job when it comes to creating the best Star Wars movies. strict application of IP when it comes to these superhero movies means they don't make many risks. They believe that everyone's going to see this movie anyway, so it doesn't matter so much the quality of the movie per se. They just need to get bums in seats and then enough for the next one too. Another argument for the enforcement of intellectual property is that it incentivizes innovation. And this is especially important in the medical field because an important innovation could lead to saving millions of people's lives. Creating new drugs is a very costly process, requires years and years of research and development, and an expensive regulatory process. Why would somebody go through all of that effort if they weren't guaranteed a profit at the end of it? The scenario usually presented is that somebody goes into all of that effort and then produces a drug, and on the day of release, somebody buys one, reverse engineers it, basically copies the recipe, and then produces it, taking away the profits of the other person, and therefore it's seen as wasted time and effort. But I think it's assuming to say that the non-enforcement of IP just decimates all profits, because there's still that time lag in between the initial release and the backwards engineering. And of course, there's also the issue of being a trusted brand. You could put that investment into gaining a good reputation with your consumers. Why, for example, are people more likely to buy the branded aspirin than the store brand, even though they're precisely the same drug? It's because they've garnered a reputation and it just seems better to them. It's twice the price. So there are many ways in which somebody can make profit. And the non-enforcement of IP doesn't necessarily mean no profits whatsoever. And also, if you're looking from a utilitarian point of view, this is a good thing because it means that the extra competition will drive down prices of the drugs and make it easier for insurance companies and consumers to jump in and get that all-important drug. Innovation in general is one of the biggest arguments for intellectual property, especially from a utilitarian point of view. But somebody actually went to the effort to make an empirical observation of whether IP incentivizes innovation. It culminated in a book called Against Intellectual Monopoly, which goes through the various studies and such things and concludes that on the whole, enforcement of IP does not really encourage innovation, and in some situations it may actually discourage it. I'll link to some of these studies in the podcast description. In the meantime, I'll give you this scenario to help make this more intuitive for you. If you have ideas, you're an innovator, but you want to make a profit, then what's more likely to produce more innovation from you? The invention of one thing and then the monopoly right to make a profit from that one thing for eternity, or the right to seek a profit with your thing, but everyone else has the right to as well, in which case you're going to look to seek profits in other sectors as well. And what other better way to do that is to make another innovation. And this little scenario here helps us to understand how authors would make a profit in such a society as well. Because yes, technically speaking, somebody else could reprint Harry Potter and make a profit out of J.K. Rowling's work. However, they are not J.K. Rowling. They don't have nearly the same skills and experience in writing they do. Her work will still be in demand. Maybe if she didn't have the sole right to make money from the Harry Potter characters, she would be incentivized to make more and more books. We'd be seeing maybe 50 books in the Harry Potter series. Who knows how this would play out in real life, except to say that people seem to think that creativity in general will just cease if there's no intellectual property, when in fact the enforcement of intellectual property is only about 100 years old anyway in its proper form. None of the great composers in classical history had intellectual property enforcement, however produced some of the most beautiful works that any human has ever produced. When looking at this topic from a libertarian point of view, it's not quite as simple as the initial setup makes out, that you have the right to produce something and then make a profit out of it. It's about justice, it's about reducing conflict, and IP violates so many of these things that are central to the libertarian platform. It's an act of aggression because it prevents peaceful people from using their resources as they see fit. It actually creates conflict rather than reduces it, and actually reduces prosperity when, presumably, we're in favour of prosperity. Therefore, whether you're a deontological libertarian or a utilitarian libertarian, intellectual property is unjustifiable. I don't expect you to be completely convinced, if you weren't before, after this, because it requires some more thought on it. Therefore, I really do recommend you read against intellectual property, against intellectual monopoly, and also just keep an eye on Stefan Kinsella because he's always thinking about these things, whether he likes to or not. So, I hope this has been food for thought. Thank you so much for listening. Please join us next week for another episode of Liberty Bytes, either with another guest host or William Gadsden will come back. Either way, I'm sure it'll be just as enlightening. If you've enjoyed this, please give us a subscribe. Make sure you check out think-liberty.com for all the other podcasts and articles. And we'll see you next week. Bye-bye.